Hello everyone, I am Dr. Enak Lakshmi, Assistant Professor, Department of Commerce with Finance in Dr. SNS Rajalakshmi College of Arts and Science, Autonomous, Coimbatore. I am here to explain a concept, Introduction to Financial Law in International Financial Law. That is in the course International Financial Law. Now we are going to see the legal side of the financial market. So financial market is a very big market where securities, all the securities will be transacted. Not only securities, even derivatives, commodities, everything will be transacted. So the public is dealing with that. So that financial market should have a legal side. That is, there should be proper regulations, rules and regulations, because it in order to safeguard the consumers. Now we can see the role of law in financial market. So it provides legal certainty and predictability for financial transactions. So all the regulations, that all the law should have certain legal certainty, that is, it should possess legal certainty and predictability. Then the second role is ensures enforceability of contract. So contract means that it is there should be an offer, there should be an agreement, it should have some considerations. So it should be properly enforceable by the court of law. See, what are the things that is transacted, means derivatives, securities, debentures, commodities, everything. Now we are going to see the that is the third role is facilitates dispute resolution through courts or arbitrations. So for everything there will be some problems may create. Those problems has to be resolved. Okay, so those disputes has to be resolved through courts or arbitration. Now we can see the key legal concepts. So what are the key legal concepts? Contract law is there, property law, trust law, securities interest. So for every transaction there will be a contract. So there should be financial agreements. Property law. So all that is property law means the ownership and the transfer of the ownership. So there should be some relevant law in order to ensure this ownership and transfer. Next is trust law. Trust law means asset management and securitization. So there should be trust law. Next is securities interest. What is securities interest? Protect creditors through collateral mechanism. So the person who is lending, who is accepting the securities as the collateral thing for lending the money. So for that, what is the interest or the charges to be paid to the creditors? So the creditor should not get they should not get affected due to the getting the securities as collateral. Next is, we are going to see the regulatory side of financial market. So what are the regulatory side? So the regulation should have some objectives. What are those objectives? Market integrity, consumer protection, systematic stability. It's a very important objective. So that is in order to protect the investors from fraud, insider trading and manipulation. Likewise, consumers to be protected. They have to be safeguarded. That is, the retail investors from unfair practices. Then systematic stability. What is the systematic? Prevent financial crisis and reduce systematic risks. So this is the objective of the regulation. Now we are going to see the key regulatory bodies. Some examples of key regulatory bodies. There are many regulatory bodies. From that we have taken some, that is national, that is 3 regulatory bodies from various countries and 3 international and transnational bodies. First, in national, we are going to see the examples of the national regulatory bodies. That is Securities and Exchange Commission, SEC. This is the regulatory body of United States. Likewise, Financial Conduct Authority, FCA. This is the regulatory body of UK, United Kingdom. In India, there is one regulatory body in order to regulate the financial market, capital market, that is Securities and Exchange Board of India. Then now we are going to see the international and transnational regulatory bodies. BIS, Bank for International Settlement, IOSCO, that is International Organization for Securities Commission, FSB, that is Financial Stability Board. So these are some examples of the regulatory bodies. Now we can see what is the framework of the regulatory body. So it contains prudential regulations, it contains conduct regulations, then regulate anti-money laundering, and know your customer. So these four important things are taken, that is are given more importance, and it has been framed in the regulation. Now we are going to see the overview of types of financial transactions. So which are the transactions that is transacted in the financial market? Debt transaction, equity transaction, derivatives transaction, securitization, repo, and securities lending. These are the 5 important types of financial transactions. So debt transaction include loans and bonds. Equity transaction includes share issuance, public offering, private placements, everything. Derivatives include options, futures, swaps, and all. Next, securitization includes pooling of financial asset into tradable securities. And the last one is repo and securities lending. That is, it is used for liquidity management and collateral transfer. So these are the types of financial transactions. Now we are going to see the financial risk and what is the stability and regulations. Now first we can see what is meant by financial risk. So credit risk, market risk, liquidity risk, and operational risk. These 4 risks together constitute financial risk. So what is credit risk? Counterparty default. What is market risk? Price and interest rate fluctuations. What is liquidity risk? Inability to sell assets or raise funds. What is the operational risk? It is failure in internal systems or processes. So these are the common risk which is found in the financial transactions and in the financial market. Now we are going to see the stability concerns. So in order to stabilize these types of problems, to what are the stability concerns? Too big to fail institutions. That is, if the financial transaction is very huge, then there are more chances for institutions to get failed. Then contagion effect due to crisis. We cannot say when the crisis comes. There was a very crucial financial crisis in the year 2008, where the banks were that is where the banks were totally closed in US and all. Next is shadow banking and unregulated sectors. There will be shadow banking. Shadow banking means it's not comes under the regulations. And unregulated sectors where no regulations, no laws are there. So due to those things, risk will occur. So what are the regulatory rules in order to stabilize the financial market? Capital adequacy requirement, liquidity coverage ratio, resolution mechanism for failing institutions. So these 3 are the very important regulatory tool in the financial market in order to avoid the financial risk. Now we are going to see the law of international finance, that is conceptual understanding. So now first we are going to see what is the nature and scope combination. So the national law and the law of the other country where we are making the transaction. So it should be combined. Combination of domestic law, transnational norms, and customary practices, often governed by English law or New York law due to commercial certainty. So the person from that is India and a person from England is going to have a financial transaction. So the law of both the countries has to be combined together in order to safeguard their transaction. Now we are going to see the key areas. What are the key areas of international finance? Cross-border lending and investment. Cross-border means that is crossing the border of the countries. Next, conflict of laws. So conflict of laws, sir, certainly we cannot say all the law will be that is, if we combine both the laws everything will get settled down. No, there will arise some conflict between the law to adopt which with which country's law, like that. Next, sovereign debt and reconstructing. Next, international financial institutions. So IMF is there, World Bank is there, so it is common to all the countries. So this is the international financial institutions, they have to, if they are financing to a particular country, the the law of that country and the law of these financial institutions has to get combined, and it has to be properly set in order to make the financial transaction a successful one. Now we are going to see the last topic, legal techniques in international financing. So what is a legal technique? Legal technique means the problems which has been arise has to be properly resolved. So netting, set off, collateralization. So these are the very important legal techniques in international finance. Use of these standardized documentation has to be, if everything is properly undergone with the rules and regulations of the domestic law and international or transnational norms, then the problems cannot arise. So if everything will function smoothly. Thank you so much for your patience listening.